I mean, if you go back to a place you haven't lived in 2 years and you start peeking through the windows, and now you're in here telling the judge that
This case starts off sounding almost ridiculous, but within minutes, it turns deeply unsettling. A man shows up in court claiming he thought he still lived at a house he hadn't stepped foot in for 2 years, after being caught peeking through the windows at 4:30 in the morning. The judge isn't buying it, and as the facts come out, alcohol, memory gaps, and some very troubling behavior collide. What begins as a simple plea hearing quickly becomes a serious conversation about accountability, substance abuse, and public safety. Stick around, because the judge's reaction and the turning point is something you don't see every day.
here says 12 to 18 months. Do you understand that?
He had said 12, Judge. I know that I think he crossed part that said 18 out.
Okay, well, I may still go 18, I may still go 12, I don't know, but
Fair play.
okay. But do you understand that, sir?
Yeah.
All right. And you understand if you plead guilty, the possible penalties are up to 500 fines, 90 days jail, costs of all those. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
All right. Okay. Any questions so far?
No.
To the charge of window peeping, how do you plead?
Guilty.
On November 13 of 25 at 4:37 in the morning, were you at or near 19116 Hyde Park Court in Woodhaven?
Yes.
And you lived in New Boston, right?
Yeah.
And you were looking inside somebody's windows
Yes.
at 4:30 in the morning?
Yes.
For what purpose? Just be honest with me.
I'm sorry.
Was he intoxicated? Yes?
Yes.
Well, I can't take his plea if he can't make out a factual
Well,
basis.
I think he has sufficient recollection to be able to handle this. I just think that some of the finer details might be.
Well,
He recalls looking in the window.
why were you looking in the window?
I used to live there.
You were looking in the window. You used to live there with who?
My dad.
Who's your dad?
311.
Same name?
Yeah. May I, Your Honor?
Yeah.
So they had previously, that was an address that they had previously lived at. So they had subsequently moved, but he found himself back at that address.
What were you doing looking in what window?
I'm not sure now.
You just looked in the window at 4:30 in the morning?
Yeah.
Did you know the people that were living there at the time?
No, I thought I lived there. So,
You thought you still lived there?
Yeah.
What did you consume that day? How much alcohol or drugs or both?
I just alcohol.
How many? What kind?
Nick Ultra.
How many? 20?
Too
I can't hear you.
many.
Are you on probation or parole right now? Anybody force you to plead guilty?
No.
I'm going to accept your plea. I find it to be an accurate plea made voluntarily and understandingly. Please accept it. Does he have a drug or alcohol problem? Or?
He does. It was.
Well, I know, but if he's drinking this much where he doesn't remember and thinks that he was living there at the time, I mean, that's kind of scary. It's not to say that.
This is where the courtroom tone completely shifts. The judge isn't just listening anymore. He's connecting the dots. Legally speaking, this matters because a plea requires a factual basis. And when someone claims they were so intoxicated that they believe they still live somewhere they left 2 years ago, that raises serious red flags. The court now has two concerns: public safety and untreated substance abuse. The judge isn't accusing, he's assessing risk. That's why conditions like AA meetings, no alcohol, and distance from the property aren't punishments. They're preventative safeguards. Here's the real question for you. If someone drinks so much they lose track of reality, should the court step in harder or back off and trust it won't happen again?
You're going to be screened and assessed today and sentenced at a later time. I want you not to go back to 191. These are conditions of your bond. Do you understand that? I'll give you $1,000 personal bond, but you are not to go back to 19116 Hyde Court in Woodhaven, not to be within 2 miles of there. You're not to have any contact with the victim at all. You cannot write, phone, see, text, email, or communicate with anybody there. No alcohol, no marijuana, no illegal drugs. I do want him going to NA at least 2 times per week in person. And I also want him going over to get fingerprinted and photographed today by 2 p.m. at the Woodhaven Police Department. Do you understand that, sir? So you're going to get a review here. You're going to get a sentence date. Then you're going to go down the hall and pick up the sentence date on the notice. Then you're going over to probation. We're going to notify the victim. Probation will you'll fill out a questionnaire to them and be interviewed, and then you'll come back for sentence. So why don't you give me another date, Lisa?
Your Honor, if I may, will the screening done by probation, will that not indicate then that they make a recommendation as to whether or not he has any kind of drug or alcohol problem? Because I think that if we look at it just this one incident, that yes, that there are some concerning aspects of it, but I really honestly do not believe that he has an alcohol problem.
He drank so much, he thought, if one I'm going to assume that he's been truthful and thought he was going back to his house. That's a blackout to a blackout to a blackout. I mean, if you go back to a place you haven't lived in 2 years and you start peeping through the windows and now you're in here telling the judge that you thought you lived there. I mean, if that isn't indicative of an alcohol problem, I don't know what is. I mean, I'll make a determination after I read the report, but he's going to go to AA. If anything, I think I'm at least a couple times a week too late. Mr. Crawford, you see the AA verification there. So we're going to hand that to you. You're going to give it to your client. He's going to go in person.
Judge, is there any way we could delay this now? He's having second thoughts about this.
No. Are you kidding me? What do you mean he's having second thoughts? Because I ordered him to go to AA? Are you kidding? There's only one of 2 things that happen here, son. You either were drunk out of your gourd, or you were going over to the window peep somebody, or both.
Yeah.
Hang on. Listen, I don't appreciate people arguing with me. You can disagree with me. It's okay. Nobody's ever heard me say I'm always right. But in this instance, if I don't order what I just ordered, I'm a bum. If what you told me is true, you thought you lived there. You hadn't lived there in 2 years. Did I misunderstand something? Did I misunderstand something? Then you are kidding yourself. You are kidding yourself. And it's okay, I guess. I'm not going to having second thoughts because he doesn't like the judge or him to go to AA twice a week or abstain from alcohol. Which is it?
Well, I think it's more so about his condition at the time as far as the knowledge of what he was actually in fact doing. That was my concern. I'm not trying to throw a wrench in the machinery at all, Judge. You've been very reasonable this morning from my perspective.
Well, I'm not understanding though. He's looking through the windows. He's at 4:30 in the morning, which causes me to say a lot of things to myself. I mean, I wouldn't go to my house sober even and look through the windows at 4:30 in the morning. I'm going to walk in the door. He didn't even try to walk in the door. I don't know what to say to you. You act like I'm sending you to jail for 90 days. This is strange. I'll do the screening. We'll see what happens. I'm going to keep an open mind, but he's going AA. I mean, I just cannot imagine a scenario under which I wouldn't order it then. Give me a sentence date, Heather.
That'll be February 4th at 9 o'clock.
Is that good with you?
That's good with me, right? Will he be, so the AA class will be done in the interim until the sentencing?
Correct.
Fair enough.
He's gonna go down the hall, he's gonna get his notice, he's gonna get an order for prints, and he's gonna get his bond sheet. My court officer's going to hand him an AA verification. He has to go in person. Every time he has to have the form signed, and then he'll come back for sentencing, and I'll revisit it, but I don't know what else to say. I'm surprised that he thinks it's unreasonable, and, you know, it's okay, you're entitled to your opinion. It's all right. I don't expect everybody to agree with me. That's not gonna happen. Good luck. We'll see you back here. Thank you very much. And you have to go over to Woodhaven and get printed and photographed.
At the end of the day, this wasn't about embarrassing someone or flexing authority. It was about responsibility. The judge accepted the plea, imposed clear bond conditions, ordered substance abuse screening, and mandated AA attendance, all while keeping an open mind for sentencing later. That's the balance courts aim for, protecting the public while giving the defendant a chance to address the root problem. Whether you agree with the judge or not, one thing is clear. This decision was driven by concern, not anger. Back-end index pointing right if you found this courtroom exchange as intense as we did. Hit that like button, share your thoughts in the comments, and don't forget to subscribe for more real, jaw-dropping courtroom breakdowns.